The courtroom didn't explode. There were no dramatic confessions, no shouting, no sudden breakdowns. Instead, there was silence. A heavy, suffocating silence that spread from the witness stand to the jury box. Because everyone in that room realized the same thing at the same time. The case they thought they understood was wrong. And the man who seemed the most helpful in the investigation was now the one struggling to answer a very simple question. Up until this point, the prosecution had built what looked like a solid case. A threatening email. A witness placed Daniel near the scene. A timeline that appeared consistent, but cracks had formed. The witness had assumed the time. The email lost its meaning in context. The crime scene felt staged. The assistant knew details he shouldn't have known. Now, the courtroom was about to see whether those cracks were small fractures or the beginning of total collapse. Because suspicion is powerful, but the proof is final. The defense called Mark Ellison back to the stand. He adjusted his jacket before sitting down, calm, composed, almost rehearsed. For 6 years, he had been the victim's assistant. He managed finances, scheduled meetings, had keys to the office. He found the body. He called 911. He cooperated fully. He was the model witness. Until now. Mr. Ellison, the defense began evenly. You testified that you left the office at 7:15 p.m. the night of the incident. Is that correct? Yes. And you did not return? No. The defense paused just long enough for the jury to settle in. Then a screen illuminated behind him, phone records. At 9:41 p.m., the defense continued. Your phone connected to the victim's home Wi-Fi network. Mark blinked. It must have connected earlier, automatically. The defense zoomed in on the timestamp. 9:41 p.m. new authentication. Automatic connections do not create new authentication records, the defense stated calmly. The room grew quiet because digital data doesn't assume. It doesn't misremember, it records. Next came traffic footage, a city surveillance camera positioned to blocks from the victim's home. Timestamp, 9:32 p.m. A sedan entered the neighborhood. The license plate matched Mark's vehicle. The prosecution shifted uncomfortably. Earlier in the trial, they emphasized that Daniel's car had been possibly seen nearby, possibly, but this wasn't possible. This was confirmed. 9:32 p.m., Mark swallowed. The jury didn't need instruction. The timeline was redrawing itself in real time. Daniel's supposed presence now looked uncertain. Mark's presence looked undeniable. The defense returned to something that initially seemed minor. The audit report, discovered on the victim's desk. Dated 2 days before the murder, it documented a pattern, multiple small transfers under $5,000 over several months, individually insignificant, collectively substantial, each approved by Mark. The defense displayed email correspondence between the victim and Mark. I need this resolved immediately. Failure to repay will result in termination. Legal action will be considered 48 hours before the murder. The defense asked gently, were you aware your job was at risk? I don't recall the exact wording. The defense read it again, word for word. There was no ambiguity, no misunderstanding. It was clear. The victim had discovered financial misconduct, and he had confronted the person responsible. Suddenly, the motive shifted entirely. This wasn't about Daniel's failed business deal. It was about exposure, embarrassment, criminal liability, and desperation. Then came the moment that truly changed the temperature of the room. The defense replayed footage from Mark's original police interview. Detective, how did you enter the residence? Mark, I used the spare key under the garden light. The video froze. The defense turned toward the jury. That detail was never released publicly. Police confirmed it. No press release mentioned the spare key. No public document referenced its location. Only investigators knew, and the person who hid it. The defense looked back at Mark. How did you know where the spare key was? Mark hesitated. I assumed that's where it would be. There was that word again, assumed. But assumptions don't give precise hiding spots. They don't identify under the garden light. The silence that followed felt heavier than any accusation. Because it wasn't just suspicious, it was specific. The prosecutor objected. Suggested Mark could have seen the key on a previous visit. Suggested coincidence, but records showed the victim placed that key discreetly, without informing staff. No emails referenced it, no messages mentioned it. There was no documented reason for Mark to know, unless he had been there that night, unless he had used it. The judge called for a short recess. As the jury exited, murmurs filled the courtroom. Reporters typed quickly. The narrative was unraveling, and everyone could feel it. The next morning, something was different. Mark was no longer seated among the victim's family. He sat at a separate table, beside his own attorney. Daniel remained where he had been throughout the trial, but the weight had shifted. The prosecution's tone changed. Careful, cautious. They no longer spoke with certainty. Because certainty had betrayed them, the defense delivered one final sequence of questions. If you were not at the house at 9:41 p.m., if you did not return that evening, if you had no knowledge of the spare key's location, they paused. How do you explain your phone, your car, and your statement? Mark opened his mouth. No answer came, and in that silence, the case collapsed. Later that afternoon, the prosecution made an announcement. They moved to dismiss charges against Daniel Reeves pending further investigation. A wave of quiet gasps spread through the courtroom. Daniel didn't celebrate. He didn't smile. He simply exhaled. Because relief doesn't erase months of accusation, but it does restore something essential: freedom. Mark, meanwhile, was escorted from the courthouse under entirely different circumstances. The investigation had officially changed direction, publicly, irreversibly. Justice rarely looks dramatic. It doesn't always arrive with flashing lights or confessions. Sometimes it arrives through careful questioning, through patience, through someone willing to challenge what everyone knows. If no one had questioned the timeline, if no one had examined the financial records, if no one had replayed that interview, an innocent man might have lost decades of his life, and the real killer might have walked away untouched, all because of an assumption. And sometimes that's the most disturbing part, not the crime itself, but how close the system came to getting it wrong. All it took was one question, and the courage to ask it. Comment if you believe the truth can be hidden in plain sight. Subscribe for more shocking true crime stories that defy belief.